How do drug DUI laws differ by state? Have you ever wondered how the laws around driving under the influence of drugs change from one state to another? It's a topic that can be quite complex, but understanding these differences is essential, especially if you or someone you know is facing charges. Let's break it down in a straightforward way. First off, drug driving under the influence refers to operating a vehicle while impaired by drugs. This can include illegal substances, prescription medications, or even over-the-counter drugs. Unlike alcohol, where there are standard limits for blood alcohol concentration, drug DUI laws do not have uniform measurable thresholds. This makes it tricky to determine impairment levels across different substances. Now, let's look at how states vary in their legal standards. Some states have zero-tolerance laws. This means it is illegal to have any detectable amount of certain drugs in your system while driving. This is often the case for substances like marijuana or controlled narcotics. Other states might have per-Southeast laws, which set specific limits for drug concentration in the blood, similar to alcohol. However, these laws are less common and can differ based on the type of drug involved. Many states focus on impairment-based laws, where the prosecution must show that the driver was impaired enough to make driving unsafe, regardless of specific drug levels. Next, let's talk about testing and evidence. States have different implied consent laws regarding drug testing, most requiring drivers suspected of drug impairment to submit to chemical testing, which can include blood, urine, or saliva tests. Refusing to take these tests can lead to separate penalties in some states. Additionally, some states mandate testing in serious accidents, while others do not. The types of tests accepted and what substances are screened can also vary, impacting how drug impairment is proven in court. When it comes to penalties and sentencing, the differences can be quite stark. Penalties for drug DUI can range from fines and license suspensions to mandatory jail time and installation of ignition interlock devices. Some states have harsher penalties for repeat offenders or if aggravating factors are present, like accidents or minors in the vehicle. There are also specialized categories, such as driving while ability impaired, which may carry lesser penalties in certain jurisdictions. Marijuana laws are another area where states differ significantly. Some have zero tolerance for any presence of THC, while others allow for specific limits. Prescription medications that impair driving are treated differently as well, with some states requiring proof of impairment regardless of legality. For those involved in criminal defense, understanding these state-specific laws is vital. Defense strategies must consider the unique definitions, testing protocols, and evidence requirements of each state. Challenging the validity of drug tests is often a key part of the defense, especially since detecting impairment from drugs can be more complicated than with alcohol. Knowing the penalties in each state can help in negotiating plea deals or seeking alternative sentencing options. In short, drug DUI laws vary widely by state in terms of how impairment is defined, tested, and penalized. This knowledge is essential for anyone facing drug DUI charges, as it can significantly impact the legal approach taken.